kia hau kia mātou no hoki he waia ta harikoa. Harikoa no te mea ko ngā kupu kei te whakaatu ki te iwi e tūkaha ana te iwi Māori.
What inspired you to write Maranga Ake Ai?
At the time, it was the 80s, and te ao Māori was like a big taniwha waking up from a slumber.
Words like freedom from oppression.
So you were kind of almost railing against the system with that song, eh?
Yes, I was.
Yes.
Yeah.
Now you're a knight, now you're a judge. How do you reconcile those two things now?
Yes, well, you can't really.
How much longer must we keep on talking? A million miles already, and we still go walking.
Your sister Tanya said you don't often sing that. You get called upon to sing that.
Yes.
Why is that?
I just don't want to be the sad old bugger that gets trotted out to sing a song from a generation ago. I don't want to be that guy.
That guy is Joe Williams, former judge of the High Court and Court of Appeal, youngest appointed Chief Judge of the Māori Land Court, former chair of the Waitangi Tribunal and first Māori on the Supreme Court bench. In April, Justice Joe Williams was knighted at his Ngāti Pukenga marae in Manaia.
The coolest thing of all was watching the effect that the weekend had on the Manaia people and Ngāti Pukenga, because it was profound. You had Supreme Court judges, Court of Appeal judges, High Court judges, Chief District Court judge and a whole pile of Māori judges from all the courts rubbing shoulders with my relations, many of whom have been clients of those processes. The investiture and the knighthood, in my view, is not at all about me. In fact, to be perfectly honest, knighthoods aren't really my thing.
What sort of conversations did you have to have with people to process that in your head?
Well, my people said to me, this isn't about you. This is about us. This is about us having an opportunity to feel pride in what we've produced, in who we are. And, you know, you can't, what can you say to that?
It's interesting, eh? Because it's like the ultimate tohu of the crown, isn't it?
Exactly. And in fact, you know, when I got appointed to the Supreme Court, people were happy, but it was the knighthood my relations really sparked off.
Joe often uses a quote by Te Kōtirikirangi, "Mā te ture anō, te ture e aki." Only the law can be pitted against the law. I remember when I came out of law school, or even during it, I felt sort of ripped off when I understood how the law was used throughout colonisation. How did you work that out in your mind that you're best placed to go in inside it?
If the law is a tool of colonisation, and it most certainly was and is, then it is also the tool of decolonisation.
Is it possible to decolonise a system by browning it up?
No, but it helps.
After Joe taught the first ever Māori land law course at Victoria University, he gained a Master's in Indigenous Rights Law from the University of British Columbia. What did you learn when you were in Canada?
In Aotearoa in 1986, if you wanted to do Māori legal work affecting the wider Māori struggle, you either worked for Māori Affairs or you were an academic, because the iwi didn't have any money and neither did anyone else. What I discovered over there was that you could be a lawyer in private practice working directly for iwi and hapu and make a living doing it. And so when I came back, I went straight into private practice to learn how to litigate, because I'd seen the power of litigation as a tool of social and potentially constitutional change. Negotiation is about the achievable, the doable, the acceptable. Litigation is about principle.
Before serving on the Waitangi Tribunal, Joe appeared before it representing claimants like Te Roroa. That was a very important claim because hard on the heels of that, the law was changed, wasn't it? To do with private land.
Oh, that's right. Yes. So that was a claim that affected, among other things, 2 pieces of private land, 2 farms around Maunganui Bluff, and that triggered a law change that said the tribunal can't make any recommendations in respect of private land.
When you were on the tribunal, was it challenging to hear claimants come in to speak about the historical kinds of losses?
Every treaty claim I ever acted on as a lawyer or presided over as a judge ended on a high note in terms of the hearings. Every one of them ended full of hope for this time being an inflection point, a time of change.
Was it challenging the fact that it could only make recommendations to the Crown as opposed to force the Crown to do anything?
No. Well, actually, yes and no. No, because treaty claims aren't like court cases where you award damages. In fact, if it had been like that, it would have been a disaster. It is much better that overall comprehensive settlement packages be negotiated rather than imposed, because tribunal might be cool, but it has no idea about the complexities and dimensions of reconstructing an iwi infrastructure. That's the first thing. Second thing, though, is that, of course, the tribunal does have compulsory powers under the State-Owned Enterprises Act and under the Education Act and a couple of other acts, but
Often didn't exercise though, eh?
hardly ever exercised it. In fact, didn't do until very recently, and I think mostly because the construction of restoration packages is really complex.
Do you think that law and justice are necessarily one and the same thing?
Oh, I don't think they are one and the same thing. Law struggles to be just, and justice struggles to find its place in law. That's the human nature of this beast, always has been.
I guess one of the big challenges is that the justice system is built on a system that's come from the Crown, that represents the Queen, and the precedents that are in case law come from there, and the judges are Her Majesty's judges. How can we go beyond changing inside the system to completely transforming it?
So you're right, the judges are the Queen's judges, and the laws are often English laws, but the Queen isn't necessarily a Pākehā, and the laws aren't necessarily English. In environmental law, in family law, in intellectual property law now, Tikanga speaks as a result of legislative changes. And then in the more recent case of Takamore and the Ngāti Whātua decision of the Supreme Court of a few years ago, the judges are essentially saying the same thing as a broad aspect of what we would call the common law, with or without legislation. So we are witnessing a relatively glacial change in the approach both of legislators and of judges to the nature of our law.
Joe often speaks of New Zealand law as sourced from both Kupe and Cook. The place and relevance of tikanga in New Zealand law was most recently explored in the Supreme Court in relation to Peter Ellis.
If you were to ask me, Joe Williams circa 1983 or 4, whenever Maranga was written, that this would be the state of our law, that our cabinet would be 30% Māori, that our parliament would be 20% Māori, and that we'd have more than 20 Māori judges, including a Supreme Court judge, a Court of Appeal judge, a High Court judge, and 15 District Court judges, I would have said, I don't believe you. Stuff is changing. I'm having conversations with my judicial colleagues about the place of tikanga in our law that were unimaginable a decade ago. And they are not seen as crazy conversations.
No more knocking on closed doors. No, sir. For Maori people, gotta wake up, gotta take up the cause. Oh, yeah.
Probably like your family, we lived in a singing family. You had to sing. In fact, if you didn't sing, you got a hiding.
Did they have garage parties?
Yes, all of that.
I love those.
In the days when there were mini tankers.
Whoa.
I think they're illegal now, but you used to be able to buy a mini tanker and you get like, I don't know, 40 or 50 gallons of beer.
Oh my God.
I know. Anyway, so us kids would get trotted out to sing a song to all the relations, and my song was Jake the Peg.
There's Jake the Peg.
Joe was raised by his great-uncle and great-aunt in Hastings.
Our mum, when she was happy with Joe, in some ways gifted Joe to Uncle Mark.
Kind of old-style whānau.
Old style, yeah.
Mum and Dad, as I called them and think of them, had no children of their own. So someone regularly got sent down to keep the old man and the old lady company. We grew up really on Mum and Dad's pensions and my paper round and my milk run and whatever we could do in the holidays. I was working at the freezing works by the time I was 14, and that was normal to us. Had no idea I was poor until I got a scholarship to go to Lindisfarne College in Hastings, which was a decile 10 school, and got surrounded by wealth and realised actually that I was as poor as a church mouse.
How were you on the sports field?
Useless, but a big mouth.
Were you a judgy kid?
What do you mean by that?
You know, like, did you go around, look, he's getting all blooming like that now.
So, I'm getting judgy.
No, I mean, like, did you debate a lot as a kid? Did you join the school debating team?
I was really argumentative as a kid. I liked to argue.
Against the parents?
Never argued against your parents. That was very strategically unwise.
Was your brother in the mob?
Yes.
It's not unusual for families to have some go off in one way and some go off the other way.
No.
How do you explain that in yourself?
He was can I say he was a very successful mobster. And when I was younger, he had the menace tattooed across his forehead.
Wipes.
And, you know, big hulking guy. To us, he was a gentle, loving, loyal brother. He was well raised, well loved, doted on, in fact. He had a bit of cheek about him, but you know what I think was the biggest problem for him? He was big and black. He's very dark and very big. And that put him in the stereotype. And the system treated him that way. I told him that I was going to go to law school. And he looked at me. He didn't look very happy. And he said, "Are you going to be a pig?" He didn't know the difference between law school and police school. And I said to him, "Oh, no, I'm going to be a lawyer, not a policeman." And he was happy at that. And when I started working at Kensington Swan, he came and visited me, walked past reception to the lift. I told him to push the button, go to floor 11. By the time he got to the litigation floor, they'd called the police.
I knew you were going to say that.
And people were just freaking out. I said, "It's okay, he's my brother. It's fine." What I loved was he was proud. He said to me, "I'm really proud. You've done this." Yeah.
His oldest brother isn't here, like he's up there too. But I know he's proud.
I mean, he's received lots of gongs and, you know, people say you're awesome, whatever it might be. But he's no different. He's no different at home.
Joe was conscious his rulings as a judge in the High Court had a huge impact on each defendant, many of whom continue to be Māori.
The big challenge is always, what's the circuit breaker?
I don't think there is a single circuit breaker. It's a very, very complex process. The asymmetry in incarceration of Māori people is appalling. The asymmetry in removal of Māori children is appalling. There are social reasons for that, and there are institutional reasons for that. There are legal reasons for that, and non-legal reasons for that. The treaty settlement process has gained extraordinary momentum, and what that's done is tool iwi up to engage in this aspect that we've been talking about. And that's why Hemi Taumaunu's Te Ao Marama proposal has lots of iwi takers, because iwi now have the resources. What they want to do is partner with the Crown in order to leverage their resources so that they are, and this has got to be the point, centrally relevant to the lives of their people, particularly their most vulnerable.
Māori men are 7 times more likely to be incarcerated than non-Māori, but Joe believes the numbers don't tell the whole story.
So if you look at those born after 1990, the incarceration rate for that group falls off a cliff. And no one seems to know that. Absolutely falls off a cliff. Now, I'm telling you, that's kohanga, kura, wānanga, that's mana Māori, that's maranga, right? And what's driving primarily, it seems to me, the high level of incarceration is our generation getting re-imprisoned because their children are not. They're being diverted.
Do you think iwi are meant to pick up all the slack the Crown has created?
So if they don't, then they've ceded that ground to the Crown. If they're not the solution, someone else is going to be.
The expectation will be that the Crown should devolve some of the resource along with the responsibility.
That's right. What the legislation is saying is we want partnerships. You read, the Oranga Tamariki Act. Partnerships where iwi want them are compulsory, right? And Oranga Tamariki has to report to Parliament, and the minister has to respond to iwi who put their hand up and say, we want a partnership. Both sides, this is the difficult human thing about it, both sides have to decolonise their minds, because both sides are colonised. And it's much more difficult in practice than people actually realise, because both sides are used to doing it in a particular way. But both sides are saying, we want to do it a different way. It's just no longer right to say, evil, nasty Crown, good angel iwi. It's not like that at all.
Coming up after the break, Justice Sir Joe Williams on partnership. The word partnership doesn't appear in any version of the treaty, but in 1987, the Court of Appeal identified partnership as a key principle.
There's been criticism that the principles of the treaty are a rewrite of the treaty to consolidate the power of the Crown.
The first reason why I don't have too much problem with the idea of principles is this. To our people in 1840, the idea of a text-related contractual relationship was utterly foreign. For them, then as now, the transaction was relational.
Yes.
It was all about relationships, right? In my view, the concept of partnership is such a powerful concept. I know not everyone agrees with me, but because that's the relationship. That word is the essence of an equal, horizontal, as opposed to vertical, relationship. Iwi are starting to impose requirements on a Crown that needs the partnership as much as the iwi do to solve problems that the Crown no longer has the ability to solve. So the mutuality of advantage is exactly what the treaty was all about. Exactly. But it takes imagination and courage and risk. I mean, you always risk in a partnership losing something of yourself in it. You always risk the other side of the partnership not being straight up with you and running off with the goods.
When has the Crown demonstrated that partnership, that principle of partnership in a very real way? When has that happened?
Well, fair question, Moana. So the alternative is not to do it. Then what?
Joe grew up in Hastings, so did Dr. Moana Jackson, who Joe describes as a navigator, always with an eye on the destination, a warrior philosopher.
Moana said to me in a recent interview that decarceration is impossible without a conversation around decolonisation. What do you think about that?
Well, I think that's dead right. But that's the conversation we're actually having. There's no doubt about that in my mind. We are having a decolonisation conversation. We've been having it for a generation, and it's gathering momentum now.
One more time.
You forgot to name check your partner and your children during your thank you speech at your investiture.
And I'd just like to add to Joe's thanks, of course, his utter, deep, abiding love and thanks to his wife and family.
What sentence was handed down to you for that?
I got a Section 106 discharge without conviction
Too easy.
on condition that I did the dishes for a month.
Are you appealing anything?
There's no appeal from that sentence.